Yo, 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 what's good, beautiful people? Peace, love, and law. Welcome to In God We Trust Academy podcast. Today, we in work session season 7. Appreciate everybody tuning in for sure. How y'all doing in here right now? Yeah, Jordan, you can do that. Got about 5 more minutes, guys, before we get started, man. Like, share, subscribe. Let us know where you're tuning in from right now. Sir, yes, sir. We got just a few more minutes to go. In the meantime, we're going to literally give you guys some info for you guys, some great announcements we need to make to you guys, get you on the right track of some things. Okay, as of right now, we have a free ebook called The Creditor Slayer. And you can get a free ebook right now if you purchase 2 raffle tickets from myself or any other member of MNRP. And it's a raffle ticket for a chance to win a 2026 Toyota Camry. And also the second, third, and fourth will be able to win $500 cash prizes as well. It's going to be located in Huntsville, Alabama. The event is a pop-up event. So you'll be able to, if you want a vendor or anything like that, you're more than welcome to come. It's going to be a nice market that's going to be created there for you guys to do and entertain. I don't know. Maybe we can get Ricardo out there with his games and stuff like that, man. We're going to see. For sure. But to the rest of you guys, though, equip. And this book's right here is going to literally equip you with how to crush fraudulent creditors. It's going to teach you how to crush those fraudulent creditor denials and teach you how to demand original contracts, no fakes, no screenshots or anything like that. Also teaches you how to make the agencies, these credit agencies, fully go and do investigations the right, correct way. And you get to examine the investigation. But it's also going to teach you how to build 10 plus positive accounts, unlock high limit funding plays banks don't advertise, and court ready strategies and templates that you guys can be able to use at your own discretion as well. Okay. Great deal for you guys. It's about 50 pages long. Very well put together ebook for sure. So check that out. And also paid in full October 25th. October 25th. Do not forget, October the 25th, we're going to do paid in full. And the paid in full class is where I teach you how I took a $25 money order and literally settled a disputed debt with a bank, and I forced their hand and walked away with a car title free and clear. And just know it is proof of the record of so. If you're on TikTok, you can go look right now. And if you're on Facebook or anything like that, you can go see where the class is promoted at. The proof is in the pudding. But the thing is are you ready to do the work and be able to receive the same results? And you're going to have to put yourself in the situation to do so. Give yourself the opportunity. You can gain this information, you can know it, but if you're just going to sit on it, then it's going to become useless to you. So we have a VIP section as well. It's going to be a 3-hour workshop. So that's where we literally sit down and we do everything with you and make sure that everything is put together. You're going to do the work, but I'll, speak to you guys, answer you guys' questions, and get you on the right direction on which way to go as well. All right. And the other tier is just a regular tier. It does come with the templates, etc., but it won't be joining the workshop. But you're more than welcome to do so. Go and check that out again, October the 25th, 2025. They give you guys some time. The donation is for $200 for the second tier, and for the top tier, it's $400 for the VIP. But again, like I say, it comes with a lot of attributes as well for you guys to be able to use and get you on the road to getting those card titles that you truly deserve. Because they're gonna mess up. They always do. I just want y'all to know that they're gonna mess up. They always do. All right. So don't forget about those things that we're going to have going on. Also, every Monday, Wednesdays, we do this. We did change the time today. It's supposed to be at 11 a.m. Central Time today, but today we did it on 6 p.m. So I had to remove it. So that's the only way that it changes. But other than that, we're here at 11 a.m. on Mondays and 6 p.m. on Wednesdays. All right. But I didn't want to leave you guys without doing this today. So here we are. All right, so I think it's about time. Can we hit the record button? We're going to get started today. All righty. Peace, love, and law, everyone. How y'all doing in here? Welcome to Work Session Season 7. Y'all all right? I ain't heard no noises, nothing. Y'all good?
Doing good. How y'all doing over there?
Indeed.
We're doing pretty good. Doing pretty good. Still moving, still kicking. All
The
right.
storm hit yet?
It rained a little bit, kind of went over a little bit, but it ain't quite over yet. But we all right. We is in the clear. All right. So let's talk about it, man. It is time to get these testimonies in. We give thanks to the Most High for this beautiful day. Thanks to you guys as always, and just everything that has transpired up until this very moment. Everything that you guys hear from this point forward is for educational, religious purposes only. Anybody seeking any form of legal advice, please do seek a legal advisor. All right. So, what's up, everybody? Y'all got a testimony? Anybody got something to say today? Anybody going once? Going twice? Y'all stop acting like God ain't doing nothing for y'all life. Yeah. It's real, man. Just to be able to sit here and learn this and it start even making sense to you is a form of a testimony because, again, this is the work that you've been putting in. Yeah. You've been putting in this work. I've actually talked to somebody today and they son had class today and he went to court, and when he got to court he literally I guess it was a bench trial, some other things that happened, but anyway, we did a couple of motions and requested a couple of things for the record, and this judge, I guess, and most of the time when they try to run these type of trials by fast, they don't be looking at the documents. And a lot of these judges are lazy. They look at it like, I got a bunch of cases on my desk. I need to get through these quick as possible. So they're going to treat you in the most, yeah, it's not going to be what you think. But anyway, we put all these documents in. And the judge allows the officer to testify. And when testifying, um, he just said the officer's right, and that was it. Mind you, he denied all these motions, especially the motions declaring evidence for them to produce the body cam and all of these, sworn affidavits by the witnesses and everything, right? And I know why they did it like that. They did it that way simply because, like I said, they don't want to deal with it. Push it on, move it on, because now it has to go up to the next court, which would be the circuit court of that particular state or whatever county. And, you know, all of that goes into accounting. But it's just so easy to like, since we've been talking about this, like, it's too easy. They can do a trial de novo where they have to redo a full new trial if they want to, but it's too easy. And I'm saying this is a testimony because I can just see it clear, like all the violations already violated due process. You didn't even get this man the opportunity, but yet you are allowing an officer to sit here and say these things, but we're requesting these evidences, these things that's supposed to back him up as evidence. We want all of that. None of that was given. And the judge and the prosecutor actually said, hey, we don't have these things for you. Yeah, we don't have these things that you're requesting. Do you want to proceed? If you don't have what I'm requesting, then I'm going to say that you need to dismiss this case for a lack of evidence, failure to prosecute for lack of evidence. Because I've asked these things, if this is your witness and I ask for these things to be produced so that we can see and examine everything and prepare our defense, I wasn't allowed to do that based upon not receiving the bill of particular, these things that I'm asking for through the form of discovery. And you denied everything, so you don't have to have a motion to hear those things, right? That keeps the judge having to go back and, having to come back, and we got to deal with a hearing for these particular motions. But anyway, it's an easy win. Going to easily do a motion. First, we're going to do a motion to vacate the judgment right before we do the appeal, but we're going to also go ahead and put the notice of appeal together and just have it ready. But we need to do the motion to vacate because that is going to help show up in the appeal case to show that we exhausted all remedies in the lower court before we came to the higher court. So now they can see that you still asserted a right, even in the wrongdoing of the particular court. And again, they're going to look at you like that. I told y'all they will try to run circles around due process because they look at you and say, hey, you're not a lawyer, so I know he don't know. We're going to just skip this, do that. And yeah, you should take this. They try to P. Diddy you. Take this, take that. You know what I'm saying? And no, we're not taking any of this. So we have to change the narrative very fast. And the only way to do that is, again, to make sure that you exhaust all remedies, And if you see these procedures are about to attempt or cause you harm, then we're supposed to do it what, guys? Go to the higher court and do a writ of prohibition or writ of mandamus. Just depends on which one, what is necessary for the actual situation. That's what we're supposed to be focused on, right? Absolutely. So, it's going to be easy to do it. I'm saying that, I'm going to say that just because of all the studying that we have been doing for, we're going to say since season 5, 6, and 7. Those particular seasons for sure. All of them for sure, but the last few seasons because we've been focused on the due process. We've been focused on procedure. We've been focused on, all of these things that they have to abide by, and they have to abide by according to the letter of law. They they can't slip up. They can't make an error or a mistake because if it does, it affects the due process and it can leave the door open for whoever maybe they are considered to be trying to prosecute or adjudicate at the time. So that's a testimony within itself just because we already have the knowledge of what to do. Like, even if we had to take it all the way to the Supreme Court, it's easy. It's too easy. But anyway, I see some hands up. Mrs. Parks, what's up? Reporting live from where? At the tip at the tip of the earth.
Nah, but next month it might be Hawaii. Just to give you something.
What's up, though?
I just wanted to tell you, not much. Hope you guys are doing well, by the way. I just want to I think you asked about testimonies. I was trying to get in, so I just wanted to tell you, although I haven't gotten a full win yet, I must tell you that the administrative process, that was one of the things that I learned, and I kind of grasped it a lot quicker than a lot of the other things. And I used a lot of that when I was corresponding with my current lawsuit, which is, it is crazy. It's out of crazy. But today I spoke with my attorney because I was trying to file a complaint against the lender. But he was like, "Lorraine, please don't submit this complaint." But anyway, I was like, "Why?" He said, "Well, the lender itself told their attorney, like their attorney looked at all the communication that I gave to them, and it's like they really got upset with all the communication that I gave to them, and for them ignoring me, they pretty much put themselves in that place, which is why they wanted me to sign that waiver to not sue them. They're really, really adamant that I signed that waiver to not sue them. But it just goes to show that, just listening to you and that administrative process really, really worked. But also it worked against me. So it's a double-edged sword, to be honest with you. It's just because this is a business, it just put me at a major disadvantage. If this was personal, I think I would pretty much be blowing these people out of the water. But because it's business, I'm at a very bad disadvantage. But all is not lost because I made them realize they're really exposed. So I guess the plan moving forward is whatever, the things that I've gotten them on, I just have to have proof. But I guess when I get the proof, getting those secondary complaints with like the regulatory agencies will present a bigger win for me, whether or not I can sue them or not. So, but just having that proof, I can take that to the regulatory agencies and give them that way. Okay, I'm not going to sue. Y'all have big pockets. Okay, I'm not trying to drain them out. I'm trying to sue. I'll take it to another party.
Right.
Just want to say thank you.
Well, thank you for sharing that with us. Thank you. I'm not even going to really say you at a disadvantage because of it being a business. I know since it is dealing with the business, you're having to, you still having to deal with a lawyer on that case.
Yes. Oh my
So
gosh.
it makes it a little harder for some things.
Yeah, it really makes it really hard because right now, just to kind of give you an update, the defendants have not obeyed the order, so they did do a motion for contempt. And I told them today, like, hey, this thing is just dragging out. And although it doesn't feel like I have an actual win, my actual case is really strong against the defendants. It's just they have to be more aggressive to tie up the loose ends because I think if they were a little bit more aggressive, these people would do what they need to do. But because they're more like they're actually playing like defense. So when they do something, that's when they respond. So if they were more so offense on the offense, I think we'd be moving them along a lot faster. But you know, they're cautious, obviously, right? Because they want to make sure that I win. Me, I want them to be like a beast, get them, but they're very cautious, and my actual case is looking good. So I have to, I have to like learn. Like I've swung the sword so much, I could really just sit back and just put my trust in God that it'll happen. But I'm over here. I woke up this morning wanting to swing the sword again, and it's like me having like discipline not to want to go after everybody has been my biggest like toughest thing that I'm actually facing.
Right. Well, I know exactly what you mean. So, sometimes you got to deal with things as they come, but you'll win. It's all in your favor anyway because y'all got the evidence and truth on your side. So, but I'm gonna say congratulations ahead of time.
Appreciate it. Thank you so much.
Authorized representative, what's up?
Hello, hello. Can you hear me?
Loud and clear.
Thank you. I hope everybody is well. I'm speaking on I believe this is a win. My son and I are renting a place. We have an eviction case pending. My son did a plea tender on the case, but the case got continued because the other side didn't have their stuff that they needed. And in the interim, I actually sat down and read the contract, the lease. And this is something we have to really reiterate to read. I mean, every single solitary word. So I discovered that the lease, when they created it, they dated it for we moved in February 2024, and they dated it like, how they put the beginning date and the end date. So the end date would have been 25.
Right.
2025, like year's lease. So they put February that we commenced the lease, started the lease on the February 2025, and it ends on 2024. So that was the first wrong date. Then when we signed it at the end, they were signing it for 2023. I didn't ever notice this, and I'm sure my son didn't either. Doesn't that void the contract?
I mean, if they signed it wrong, it does anyway because the dates are wrong. So,
yeah, they're the ones who signed on the 2023 line as the end. So anyway, I counted that as a win because they don't have a leasing, as far as I'm concerned, because it's not a legal document, because it's not, the dates are incorrect. But I just counted that as a win, and I wanted to reiterate, because I have been going over season 3, how reading is so powerful and how these contracts have everything we need in them. And I'm just glad that going through all the work sessions that I have come to the realization, because when I started following you in July of 24, I could not understand anything you were saying. I could not make out what you were talking about. I was like, man. So I just hung in there and started buying the classes and stuff. But I'm getting a very good understanding. We were able to get our UCC filed with the secretary after we had a little pushback at the in DC, but we were finally able to get those filed, and we conveyed our security certificate with the UCC because we couldn't get it on the record anywhere. And now we ready to start, performing on some of that stuff. But I do count the eviction case as a victory. Not only that, because we did the plea of tender already. So that will be the next part of the consideration. But the fact that the contract was wrong, I've counted as a win. So that's my testimony. And thank you for advising and letting us know that we actually need to know this foundation. We need to read this stuff because it's so important. So thank you again. And I definitely appreciate this platform. And I know my son does as well because he's learning a lot. So thank you again.
Absolutely. You're welcome. You're welcome. All right, guys. Y'all know what today is? It's my turn. Today is Q&A day. Are you ready? So today we're gonna be coming from the reinstate the driver's license class and the hidden evidence. We got 50 questions. 50. Y'all ready? Are you guys ready? I don't hear no noise. They not ready.
Ready.
Okay. That's something.
Let's go.
Yeah, but we got a bunch of non-respondents on here. We're gonna need to see and send the yeah, we need to send somebody to you guys.
My hands was wet, but I'm ready.
Oh, okay. All right. Making sure. Drink me some of that good old coffee. All right. So now let's get started. We'll start with the reinstate driver's license. So, what legal authority allows states to suspend or restrict driver's license for unpaid child support? What do you guys think that is? Come on. Don't be shy.
Repeat the question.
The question is, what legal authority allows states to suspend or restrict driver's license for unpaid child support? What y'all gonna do? Y'all
I
scared?
want to.
They don't have the authority.
Yeah, that's what I want to say. They have no legal authority.
I was gonna ask, was that a trick question? They don't have the authority.
What do they do it by? What do they try to implement it by?
Procedure.
Title 4D?
Title 4D. Correct. And other corresponding statutes of the states. Okay. Why is proper service of process critical before any child support obligation can be lawfully enforced? Again, why is proper service of process critical before any child support obligation can be lawfully enforced?
Due process.
Oh, what'd you say?
Due process.
What is due process? Yes, you are correct. Okay. And it has to do with due process, and service is what actually gives the court jurisdiction, which is a part of due process. So without it, there is no valid obligation can be imposed. Great answer. You guys are getting good at this. Or maybe you guys are cheating. Which one is
Good teacher.
it?
Nah, we're getting good.
What happens to a judgment entered without valid service or notice?
Void ab initio.
I'll say what? What'd you say?
Void ab initio.
Void ab initio, which mean it is void from the beginning. Let's see if she's right. It is void ab initio, legally null from the outset. Okay. Man, y'all is really good at this. So, what methods of lawful service of process are generally recognized in civil procedures? Again, what methods of lawful service of process are generally recognized in civil procedure?
Process server.
Oh, okay, okay. Anybody
Physical
else?
physical service and certified mail delivery, fixing mail.
Okay, you guys answered it. Process server, certified mail with return receipt, or voluntary written acknowledgement. Great, great answers. Y'all went to law school or something, y'all.
It's called your cabinet.
It's called In God We Trust.
Why is a summons more than a formality in child support cases? Again, why is a summons more than a formality in child support cases? So why is it?
Because it's requiring performance.
Ooh, okay, okay. I kind of like that answer. Can we get a little deep? Oh, question everything over here telling me he on here on chat going in. He said jurisdictional requirement. Man, that's a fact. Anybody else? It is the official notice that informs the defendant of the case rights and consequences of failing to respond. All right. Which is definitely jurisdictional requirements. Okay, so what is a return of service and why must it appear in the case file? What is a return of service and why must it appear in the case file?
That's the defendant showing the court that they've received the summons and that they're going to appear.
All right.
It's
Anybody
proof
else?
of service.
Okay, proof of service. And without proof of service, that means the court lacks what, guys?
Jurisdiction.
Jurisdiction. Great answer. Great answer. All right, all right, all right. What standard child support forms or calculation must courts rely on when setting support obligations? Again, what standard forms from child support or calculations must courts rely on when setting support obligations?
Is it parental percentage?
Well,
Dealing with the money?
Ability to pay.
okay, okay, good answers. What else?
Financial affidavit.
Okay, okay, okay. Anybody else want to come on? Come on, come on, come on. Y'all doing good though. No wrong answer yet. Mm-hmm.
Income. Because it's IRS related, I guess.
Okay, so I'll just say it's basically what you said, financial affidavits or sworn income affidavits. Also, the child support guideline worksheets that is provided by the courts, etc., and compliance and deviation forms that are also. That is part of what though? Them not having their forms would be a violation of what?
Due process.
Due process. So these forms are critical to have. If any one of them are missing, that means it is what again?
Void ab initio.
Okay, okay. All right. Next. What presumption do child support guidelines generally create in calculating support? What presumptions do child support guidelines generally create in calculating support? What are the presumptions?
To pay.
You said what?
Ability to pay.
What presumptions? What are the presumptions that they make?
That you have the money to pay.
Hey, there you go. That the amount is presumed correct unless what?
Rebutted.
Rebutted with evidence. All right, all right, all right. Okay, so who has lawful authority to sign a valid child support order? Again, who has lawful authority to sign a valid child support order?
Judge.
A judge. Okay, or where permitted in statute, a magistrate or referee. But it has to be given delegation of authority. Can't just be anybody. So if it's signed by the clerk, that means that order is considered to be what family?
Boy.
Okay, okay. And if you was to happen to find that, how would you challenge that?
Be a higher court.
Anybody?
Motion to suppress? No.
Anybody else? Oh, question everything is on YouTube, spilling the beans. Y'all want me to tell you? Motion
Yes.
to vacate. Motion to vacate judgment based upon violation of due process of law. The court order was not signed by a judge. And the clerk has no delegation of authority to write a court order. This is what? This is considered a form of an ultra-virus act. You have no right to act in this capacity. We could really quo warranto the whole situation. Right? Yeah. Okay, so next question. Let's get to the next question. Why can't clerks or agency officials issue enforceable support orders? Why can't they issue orders? Why can't clerk or agency officials issue child support orders?
They don't have delegation of authority.
Because they what?
They're under Title 4D contract. So
All right.
that shows that they have an interest.
Anybody else?
No delegation of authority.
Because they lack the delegation of a judicial authority. Orders must come from a lawful tribunal. Okay, hope y'all paying attention to this. This is to help you. Okay, what is the significance of Turner versus Rogers in contempt or suspension proceedings? What is the significance of Turner versus Rogers?
Isn't that the one for intent?
Yeah, they were literally trying to put them into jail for contempt, right? So what is the significance of it? You've been saying it all day. You can say it about 5 times too.
His ability to pay is yeah.
Yes. They have to evaluate the ability to pay before jailing for non-payment. Because why? Every constitution says what?
Can't be jailed for a debt.
You can't be in prison for debt. So they have to question if it's contempt. Because if it's not contempt, meaning that you ain't going to pay it, or you just don't have the ability to pay.
Yeah, no intent.
Exactly. Great answer, guys. Great answer, great answer, great answer. How did federal Title 4D funding mechanisms create potential conflict of interest in enforcement? So how did Title 4D cause a conflict of interest for enforcement?
Private contracting.
Okay. Private contracting. Add on. Keep adding. Let's go.
Conflict of interest. Everybody had a stake in the game.
Okay. Anybody else? Come on, guys. We've been talking about child support for season 4. 4, 5, 6, 7. Come on. Conflict of interest. What's the conflict of interest?
Let me tell. The conflict of interest is, they can under Title 4D, they only get paid. They only supposed to get paid a salary. So if they on the case, they get interest on the case, and the federal funding they get. The more fathers they put on child support, the more federal funding.
So basically, it's because the state receives federal reimbursements and incentives based on enforcement, and is creating revenue motives because they are paid. They are under private contract, as was stated. So they're under private contract receiving compensation for their performance of the obligation, which now means that this can create a revenue motive. Absolutely. Right? So now, next question. Why must due process be observed before wages are garnished? Why must due process be observed before wages are garnished?
Still a due process violation if not.
First of all, what is wages? What are wages?
Property.
Ooh, it's property. Man, question everything. Own it. It's property. So you cannot take property without, what you say again?
Fifth Amendment due process or 14th Amendment.
Due process. They cannot be taken without notice, hearing, in a valid order. Okay? Yes. So now, what constitutional rights are implicated when a driver's license is suspended for child support arrears? What constitutional rights are implicated when a driver's license is suspended for child support arrears? Come on. What constitutional rights?
The Fifth Amendment?
That's due process. Anybody else? Or, well, it kind of has the right to property, to live, etc. So, right to life, liberty. But that's dealing with the federal. So you would mean 14th Amendment, since we're talking about child support, because the states is what put people on child support. So you have to deal with the 14th. All right. Chat said right to travel. Absolutely. Also what? Right to work. Also what? Livelihood and property rights. All of those things are involved when it comes to child support. And if that is so, then everything has to be handled according to due process of law. Okay? So now, what due process steps are required before a license suspension is lawful? What due process steps are required?
Proper service. Opportunity to be heard.
Okay. Anybody else? Anybody else? Y'all stop being scared. I'm gonna make y'all take a shot before y'all get on here next time. I bet y'all talk then.
I'm with it.
Well, I'm dying, boy. We been talking up a storm.
Quick, they have been here talking so fast. So again, what has to be done? Okay. First of all, there has to be a written notice, opportunity to be heard for a hearing, and an order entered by a judge and authorized officers. That is what due process has to take place, right? Has to happen. Okay. Now, what are 3 common grounds on which a motion to reinstate a license may be filed? What are 3 common grounds on which a motion to reinstate a license may be filed? Come on. We've been talking.
Aline,
You said what?
Aline,
Okay. Anybody else? What would be the main reasons you have thought? Like, in order for you to file a motion to reinstate the driver's license, based upon what reasons would you file them?
If they didn't serve,
Deprivation of
Which means what?
property, due process, violation of due
process.
process,
yes.
Lack
Um,
of what?
jurisdiction.
Okay. And also, it'd be a violation of what? Because they're dealing with what? Rights.
My rights.
So your constitutional rights. So it's lack of due process, lack of jurisdiction from the original case, and or violation of your constitutional rights, which we just spoke on, right? So that means yes, the 9th Amendment, 14th Amendment, which also deals with due process. So that's correct. Correct them undo. All right. So now, what type of evidence should be attached to a motion to reinstate? What type of evidence we looking for? What type of evidence?
The actual constitutional rights were violated, and the due process.
Which
proof of
means
service
what?
judicial.
Lack of notice. There was no
Right.
notice given to you. They just sent you a letter and just said, hey, your license is suspended. You never got a chance to go be heard or anything like that in court. You also may have certain forms of employment records which show that you didn't have the ability to pay. You was fired, you was this, you was that. Or also with your financial records, and also any case file that is in defect. Anything. Those are your evidence. Okay? Got it. Got it. Also, remember, family, it's never supposed to cause you harm. Right? It's never supposed to cause you any form of harm. No contracts. So if you are in a situation to where you're paying child support and it's more money than you're actually making, that causes you harm. So now that means that the calculation has to be wrong according to child support, because it's not supposed to place you in a form of poverty. Y'all do know that, right?
Yes, now.
Yeah. You ain't supposed to let it kill your pockets, man. You know, if you can't go from, if you was making $40-$50 an hour and then you lost that job and now you over here making $17 an hour and you still trying to pay the same child support, you done lost your damn mind. I mean, it's already illegal in other ways we have shown and proved to you, so you can exercise that. But to the people who just don't know and who need the most simplest form and probably can't comprehend everything that we're saying, just know that if you go and make less money, stop paying that same amount. You need to go right back and use due process and have it reevaluated again, because they have to do it according to due process. Due process is what is written according to the rules and procedures of the family court when it comes to child support. If they make one wrong move in there, and trust me, it's a lot in there, and they're going to make a wrong move because they're so used to doing it. They're going to do it, guys. Right? All right. The next one is, let's see what we got here. How does suspending a driver's license undermine the ability to pay child support? That's
Can't
it.
get to work,
Can't
or
get
it
to
makes
work.
it harder to get to work.
You can't get to work. You can't sustain yourself. They took your license. Now you're having to spend the money that was in for the best interest of the child. Now it's being spent on getting an Uber, a Lyft, and all of this. Yeah, this is not for the best interest of the child. We're actually causing more harm than we're doing good. Right? That's exactly what we're doing. Okay? It prevents you from work, earning wages, and making payments. That's what it does. Stupid to do that, as well as putting somebody else in jail, if you can't prove. That's why you have to make them prove it. Right? I used to wonder, like, why do they put people in jail for not, for child support? How they gonna pay in jail? Then I started realizing contempt. They started saying contempt of court. So if you show up to court and say you ain't got such and such amount of money, then you should have just said, hey, I don't have the ability to pay. I've been out of work since such and such. This is how much what I've fairly been doing. I haven't been able to do this. So we need to recalculate according to the rules of the court based on what needs to be paid or pay anything at all. Because right now I'm in a state of poverty. Anything coming out of my pockets is causing me freaking harm. You know what I'm saying? Like, I'm just saying, like, for real. And it's like that for some people, man. It's like that for some people, believe it or not. All right? But I know there's many different ways to get rid of child support, but from the most advanced knowledge to someone who's at the beginning, we got a little something for everybody to help you out. So this also helps. If you wonder why I'm speaking it on this level as well. Okay? So what protections does the 14th Amendment provide in child support enforcement cases?
Due process.
Due process.
Yes.
All right. What rights does the 9th Amendment preserve that are directly relevant to license suspension?
Unenumerated rights, life, freedom to travel, etc. Life, liberty, happiness.
Right to pursue livelihood and right to travel, right of earning, right of all the other rights that it comes into place with that, right? Let's see. How can constitutional principles of property rights be used to challenge wage garnishment or license suspension? So how can constitutional principles of property rights be used to challenge wage garnishment or license suspension? How can you use it to challenge?
Due process, 14th Amendment. If that wasn't followed and they went and garnished your property, you can't take your property away without due process. 9th Amendment, we just talked about unenumerated rights.
So pretty much it's by asserting wages and income, which are your private property. And since it's considered property, it cannot be seized without due process. Somebody said, what about the CUSIP number? Yeah, we know that. We've talked about that in other advanced classes of child support. You can do all of that, but everybody's not fully equipped and ready. If you had to get somebody ready to go to court tomorrow and who has never heard or dealt with this type of information, and they got to go to child support court tomorrow, right? Are you gonna? You think they're gonna know what CUSIP is? How to go get it? How to do any of that? They're not. So it's easier to prepare them for how to stay out of jail, which means they need to learn contempt. They need to understand the ability to pay, and being, making them prove it, because they have to show willful intent of you saying, I'm not gonna pay. Like, show me where I said that. And if you can't show me that, because you can't make that presumption if I tell you I don't have the ability to pay. Now, ability to pay don't even mean you're making the money. It might also mean that you picked up more what? Expenses. Huh. Yeah, I got more bills, buddy. Can't pay that shit. Lower that. Hey, y'all think I'm playing, don't y'all?
Businesses do it on taxes every year.
You say what, bro?
The businesses, like at the end of the year, so they could bring down their liability, they start like putting money towards expenses so they can write it off.
Yeah, man, I got expenses, bro. I can't pay. I got extra bills, extra this. Life has just been hitting me, man. Like I took on all this new responsibility. Hard for me to give you that. Look at these expenses. And guess what? They have to evaluate those things because it's according to what? Due process. Yeah, I just bought this new Grand Wagoneer. Don't look like I'm gonna be able to pay you guys that extra $250 that you was requesting. Bills went up, and I'm having to pay this. And see, I need this to get these children around for their best interests. I'm just talking shit, but I'm serious at the same time. I'm being serious at the same time, like for real. It's really a real thing. But that's why I say, man, sit there and think. But if you don't read to know the rules, then you're not going to understand what can be done, what can be said. Just sit there and think. Right? Think about it. Okay, so what alternative remedies besides reinstatement can help an obligor? You got hardship, license, and exemption claims. So you can make exemption claims and stuff like that, especially when it comes to your money. Trust, establish trust. You can get rid of all of this type of stuff, dealing with your children and all of that, right? Also, establish great relationships. I know some people are overboard with shit, but, you know, do the best that you can to keep out of this, especially if you don't have the full knowledge and information and you know, maybe even the money to gather yourself a lawyer or whatever to, you know, take care of this stuff. And even then, the lawyers don't look for certain things either. So why is it important to keep certified records from the court file, guys? Why? You know why? So we can examine everything. So, because we need to be watching everything that's being followed according to due process. And they can mess up due process in the middle of the situation. You know? You never know when it could happen. It could happen. So always, that's why I say, if you've been paying child support for the past 15 years and you ain't actually went back and sat down and looked at your case, you need to go do that. Go get all the files. Go read the child support rules of your state. Read them word for word and see if they done everything they were supposed to do. And I guarantee you, 8 out of 10 people are going to find something wrong. 2 people, they might have got you. They might have done everything to the T. But even then, there's certain things that you can prove, like we said, by them under private contract. Yeah. So remember that. So how can modification of support order help prevent future suspensions? Because again, like I said, if you don't got the ability to pay, you need to do what? What you need to do?
Rebut it.
See, I got to understand, man, they will take your ass to court saying they need more money. Trying to modify.
Going through that now with my son's daddy, and
So-
he trying to get me. I told him what to do. He don't want to listen.
So they truly understand that all you got to do is come to court and then lower it down by saying, I ain't got the money to pay it. Y'all need to lower it. You need to re-examine all income, expenses, etc. Now, when you got that trust set up, they're going to be like, well, damn, you ain't making no money. Seems like all your income and wages is in your trust. And it already belongs to the trust and the benefit for the beneficial use of the beneficiaries. So he ain't making no money. He don't own no property. See, that's what they supposed to be able to come back and reinvestigate. They come back and see ain't nothing there. You don't got nothing. We're going to need you to pay $2.50, $25 a month. That's what they're gonna hit you with. Take care of your children though. But that'll get them folks out your business. Now it's a waste of their time. Because they gonna try to find the most minimum. They'll try to say, you think you can pay at least $100 a month? Now, why you think they'll drop that low? Knowing damn well $100 a month ain't gonna do nothing. But why would they go that low, y'all? Anybody? Think you can do 125?
Just to get something.
Because what happens? What happened? What's the main purpose of this? Where does the money come from? It's federal funding. So the state want to make sure that they keep receiving this form of federal funding for that. You know what I'm saying? That's the thing. They want to keep the federal funding coming because you got to remember the private investigator that goes and look for you and finds you on your job and all of that, he get paid. You got to realize the one who makes the arrest get paid for you. The prosecutor get paid at the time. Whoever's trying to get you for contempt, they can get you. The judge is out. The court itself is making money. That money is dispersed throughout the for the court purposes, etc., which eventually ends up in the pockets of all of these people. So yeah, they're going to make sure. That's why we said at the beginning that it's what? It's revenue driven. Has nothing to do with the child's best interest. It's fully revenue driven.
So would that mean that even if the person's already in child support, they could throw it into, and they didn't have it into a trust, and they threw it into the trust in the middle of paying, it would be good?
Hell yeah, you can go be good because you can go change. Like, this is what I do. No, I ain't finna tell y'all what I do. No, I ain't even finna put that out there. I was about to tell y'all something so far, but I have to watch what I say because everybody don't deserve to know like I know. You know what I'm saying? Like, it just would be different. If I was in the situation, shit, especially if it's at a place I'm cool with and I've been working with these people for a minute, bro, hey, check this out. Let me get another application. I need y'all to fire me today and hire me tomorrow. But give me a day or two. So, cause then ain't no wages. Nothing. Ain't nothing to garnish. None of that. You fire me today. Get hired again. And by that time, everything already set up in the trust. Sure, I'm gonna have the money going straight deposited to the trust, everything. We good. Yes, sir. What's happening? I'm here. Modification day, baby. We up in this thing. We need to modify this quick. Let me show you. Hey, but if you heard me, you heard me. If you didn't, you didn't. But yeah, you got to fire me today. Hey, fire me today. And I know people, man. I know people from back in the day, like my folks, the elders in my family. A lot of them told me, man, they put me on child support. I quit the next day. Boy, I didn't get my check. They quit. Literally quit. Still took care of their children, but man, they meant ain't nobody taking no money out and they don't see it. And if you know how old people is, they work for their money, man, you better get them the folks their money and let them do what they need to do after. But don't take their money. I remember when my pops, we was eating at Ruby Tuesday back in the day, and they hit our ass with a gratuity fee. I think we had about 20 people. And they took it out his check. That man was so mad. Damn it, you stealing my money. I'm like, what? He was like, you don't take my money out. It came out of gratuity, but he didn't understand that. He was like, nah, bring me my money and let me give it to you. I was even going to give you more than what you got, which I do agree. But it's just funny. That's how, people are like, man, hey, let me give you my money. Don't just come take my money because you say you feel like you can. But I'm just teaching you guys, like, overall, man, think They had one of my sister's child fathers pay $56 a month. Boy, I tell you. But they do that because it's federal funding, though. You gotta understand, like they betting on their father to get caught up in contempt. Because once he get caught up in contempt, they finna bond his ass. Soon as he get to jail, you getting bonded. Now that $56 is times 50. Because they making money off their bond that you are connected to and serving this out for contempt of court. And you're going to have to pay. So they just made some more money off you. So yeah, it might seem like the $56 ain't nothing, but that means if he at the lowest to pay $56, he probably ain't going to pay it no damn way. And if they catch him, going to jail for contempt because he ain't going to know about not having the ability to pay. So you going to jail. And I remember they try to that's what they tried to hit me with. They told me, man, you got to do 250 days. I said, I got a court date. No, you don't. We don't got to give you no court date. I said, bro, y'all got to give me a damn court date. You just can't put me in jail for those 250 days, bro. Y'all is tripping. I got to have a hearing, for real. But that's what they tried to run game. Like, nah, ain't no court. Ain't none of that. And they was really going to try it. I had people on the outside filing stuff for me. So then they actually had to give me a freaking court date. But they tried it. And I ain't know half the stuff I know right now. I knew something. I still won, but it was just the fact that they tried it. And that's what I'm trying to tell y'all. They will try you. They will definitely try you. All right. All right. So hidden evidence. Y'all ready?
Let's do it.
All right. Now, I understand JK ain't been answering because he been giving y'all a chance to answer. But the rest of y'all got to answer. Give me some answers. What is the legal definition of subpoena? I bet somebody said, damn, now why you got to ask that?
Warrant.
What is the legal definition of subpoena? Subpoena. What do you use a subpoena for?
Use for a person to come testify in court.
Okay, great. A person to appear or to produce documents and evidence in court. Okay. Now, why is failure to comply with a subpoena considered contempt per se?
Because you're violating the court order.
It's a binding document.
Violating the court order is correct, and it does bind. Okay, so what is the difference between a subpoena ad testificandum, if I said that right, and a subpoena duces tecum, if that's right? We ain't no Latin speakers.
One sounds like, I'm guessing, witness testimony, and the other one sounds like technical, so I'm guessing evidence.
Okay. You know a little something. One is compelling testimony, and the other one compels documents and things. Absolutely. Great answer. Okay, so what is the role of a motion to show cause when someone disobeys a subpoena?
They have to have lawful justification, or I guess they want to know the reason why you disobeyed the court order. Otherwise, they'll hold you in contempt.
All righty, great answer, and you cannot answer anymore. Thank you. Great answer. All right, what penalties can a court impose for contempt of court? All right, I'm going to start calling out some names. First person I call out, you got to pick somebody else after that. Mrs. Parks, what's up?
Sanctions.
Okay, call somebody else. Pick somebody's name, call them out.
Dr. Felt.
Sanctions is one of the answers. Anybody else? Dr. Felt, your name was called. You ready?
Okay, repeat it again for me.
Okay, Mrs. Parks, can you repeat the question?
What is one of the, I think you said punishments, or what is one of the something of the contempt? What's one of the punishments for the contempt? That's the only thing I could think of.
That's right.
What penalties
Okay.
can impose?
One of the punishments for contempt. So imprisonment.
Okay, jail time. Now call you somebody else.
Okay. Ricardo.
Ricardo.
Pain. Pain, like having to pay before.
Okay. Yeah, so y'all guys answered it. Fees, jail time, and sanctions. Absolutely. Okay, Ricardo, remember, you're up to pick someone. Let's see. Why must service of a subpoena be documented? That should be easy. Call someone, Ricardo.
Brent Robert.
Brent Robert.
Could you repeat the question, Eric?
Why must service of subpoena be documented?
Well, I assume because it's akin to service of process. If it's not documented, then it wasn't done properly. So
Absolutely.
it's void, I guess, ab initio.
Ab initio. Great answer. Great answer. Let's see. What is the importance of a return of service in subpoena enforcement? That kind of was already answered. We'll skip that. How can a motion for contempt support a party seeking evidence? How can a motion for contempt
It's part of their due process.
How can a motion for contempt support a party seeking evidence?
It forces them to provide the information. The court, I guess
You're
the
right.
court.
You keep going.
Yeah.
Have some
Okay.
faith.
That's all I got.
Call somebody to help you.
Jay.
Who is Jay? We got a Jay in here? Say, it's the J Rafter. Bet y'all don't know what that come off of.
It has the picture with the college and the
That's
the
Jay.
face. Okay.
Yeah, he's been holding back on his answers.
Oh, he can't answer no more. Okay. He is the
He
one.
can
Okay,
answer.
I couldn't
He can
see.
answer. He just haven't answered at all tonight because he been chilling.
Oh, okay. Let's go with Jamel.
Jamel.
I think it's for like getting pressuring the other party to comply.
Okay. Answered. Both of you had the same answer pretty much. I was seeing if he's going to word it a little different, but that is absolutely right. It is to punish disobedience and enforce compliance. Enforce compliance. Now, I asked you guys a question. Where did that come from? What cartoon was it when they used to say, hey, it's the J Rafter? I bet y'all don't know. Y'all don't know. Y'all not no real cartoon fanatics. I tell you what, I'll give you a hint. It was a bunch of dogs. No, it ain't
Say it again.
Dalmatians. Y'all need to go back and watch.
Say it again.
Y'all need to go back and watch our cartoons, man. They used to say it's the J Rafter. Who said that? He was talking about the giraffe. It's the J rafter.
I know what you're talking about, but I don't know the name of the show.
Go find it. Go find it before we get out of here. Go find it before we get out of here. All right. Let's see who find that. All right. So next question. Why is judicial impartiality vital in evidence disputes? So why is judicial impartiality vital in evidence disputes?
He has to be fair.
Great answer. To ensure fairness, guys. To ensure fairness. No bias, okay? And not influenced by bias or conflicts as well. No conflicts of interest. So, great answer. All right, Ricardo, get ready to pick somebody. How does due process relate to compelling evidence?
Angie, our healthy life.
Angie, you able to speak or you busy? She might be where I'm on. I think she might be busy. Pick somebody else.
Pick, we got KV.
Who?
KV. Yeah.
KV, you up?
Can you repeat the question, please?
What drugs was you on last night?
The marijuana.
All right, we got you. Hold on. Let me get you the question. How does due process relate to compelling evidence?
It's imperative because it helps the person win their case.
Okay.
For their benefit.
Okay. You want to get somebody else to help you with this?
Yeah,
as well?
I do. Let me see. Angie?
Oh, yeah. She out of commission right now. Pick somebody else.
Oh. Lori?
Lori.
I knew it. I'm not sure. I haven't been to class for the past few days, so I'm not sure what the answer is.
No. You're not getting out that easy, Miss Lori.
Okay.
You're going to answer this question now. You're going to answer this.
Okay.
All right.
Um,
We believe that you can answer this. This hasn't have to be with a few days. So we just need you to know this one. Just give it to
Okay.
us. Due process. How does due process relate to compelling evidence?
I guess, does it give you, when you get the due process, you can present your evidence? Well, no.
Okay, you're close. It's the opportunity for what?
The opportunity to let your evidence be heard before the jury, or no? I'm not sure. Eric.
That's close. You're close.
Okay.
Stop beating on yourself. Just give yourself time. It's an opportunity to be heard before sanctions or evidence rulings. You were close.
Can you say that again? I didn't hear you.
Basically,
you went
notice
out.
an opportunity, okay, to be heard before sanctions or evidence ruling. So compelling these things, okay, it gives you the notice the opportunity to be heard before sanctions or any evidence ruling. Okay.
Okay.
All right.
Okay.
You got close. What legal recourse exists if opposing parties hide documents? Okay. So what legal recourse exists if they hide documents? What can you do basically?
You can
motion to discover.
Go ahead.
Yeah.
Say it.
Motion to discover.
Which is?
It's when you're asking the court to
motion. You're right. Let me help you to put it in better words, though. And the reason why, when I do ask other people, it's not that I'm saying you guys are wrong. It's just I want to see how somebody else worded differently.
Okay.
So, because everybody can have a better understanding. Because some people think or say words different, but still have the same form of meaning when it comes to what we're displaying. So, in this, it's just literally for you guys to understand that you have motion to compel, motions for contempt, or any form of seeking court sanctions. Okay?
Okay. Uh-huh.
That is what is available to you. All right. So, what can a court do if a party refuses to turn over requested evidence? That's easy.
Motion. That would be the motion to compel, right?
Contempt.
Oh, okay. Contempt.
Right.
Okay.
So what you can do is what? We
The motion.
we can strike any pleadings. You can impose sanctions, as you said, and you can hold the party in contempt or make an order for the production coming directly from the court. Now, if the court puts out an order and they disobey it, it automatically you do a motion to do what? Show cause, right? And after show cause and they didn't do or say, then you do motion to contempt. Motion for contempt, to be held for contempt of court. So
Okay.
that is in that order. Get ready to pick you somebody. All righty.
Ooh.
So why does hiding evidence undermine the fairness of a trial? Pick you somebody.
Okay. I pick, let me see. Mel P.
What you say? Mel P.
Mel P.
Okay. Mel P. Go ahead and clear your lungs out. We ready. All right, Mel P is not present. I'm finna call somebody. Karen? How you doing, Karen? We know you're there, Karen. I know you're there. I know you're there.
I'm here.
I know
I'm
you're there.
here. I'm here.
I bet y'all know what movie that came off of, do y'all?
Which one?
I know you're there. I know you're there. Who said that? Chris
I
Rock.
don't know.
Chris Rock. What movie?
Oh.
Oh, how y'all do not
Money
know.
talks.
No. Definitely not that. All right. All right. So look, are you ready? Do you know the question?
Yeah, you asked why does hiding evidence undermine the fairness of a trial?
Mm-hmm.
So, it violates due process.
Yeah, it keeps the offender from what? Basically, them from their ability to present their case.
Their case, right? It's one-sided. It won't be fair to the other party. Well, lack of fairness, I guess, right?
Mm-hmm. Absolutely. All righty
That's all I
then.
have.
Get ready to pick somebody. All
Oh,
right.
okay.
What can a court do if a party refuses to turn over? We already answered that. How does striking pleading serve as a remedy for evidence concealment?
Richard?
I'm not supposed to answer no more.
Oh, he's not.
You
Okay.
can
Jessica.
answer. You can answer.
Oh.
We'll give you this one.
What was the question again, bro?
It is, how does striking pleadings serve as a remedy for evidence concealment?
Well, if they're going to conceal evidence, then you can strike their pleadings. So, because it's not substantiated by anything. their pleadings are not substantiated by evidence, so you can strike it from the record if they don't comply.
Good answer. Good answer. That's why you can't answer again. All righty then. What is the relationship between contempt orders and constitutional due process? Pick somebody, brother.
Let's go with Mar.
Mar, you're up. Or you can answer, Richard.
What was the question?
Let me go back and find it again. I got off the page. What is the relationship between contempt orders and constitutional due process?
The relationship between contempt orders and constitutional due process. Well, it's a remedy for if they violate due process, as far as making if the court orders for them to bring documents to the record and they don't follow the court order, they do violate due process. So contempt and due process go hand in hand that way, possibly.
And with the due process, that has to be done. A contempt has to happen with a what? You have to first be given what?
Judge, you have to give notice. You have to give opportunity to be heard. Then you have to have a judge order.
Absolutely correct. All righty. What protections do litigants have if a judge disregards motions to compel? Pick you somebody.
Christy Hartsfield.
Christy Hartsfield. Christy? Y'all be being quiet on purpose, man.
I'll pick somebody else.
Next questions get you $1,000.
Ahaya Ice.
Who you just call?
Ahaya
Ice.
Yeah.
You with us, Ahaya?
Yes, what was the question?
The question is, what protections do litigants have if a judge disregards motion to compel?
What protection do litigants have? So,
Yes, what protections do litigants have if the judge basically denies the motion to compel?
denies the motion to compel.
What do you have? What can you do?
Appeal.
That's one. What else can you do? Mrs. Sparks, want to help? What's up?
Yes, Ms. Sparks.
Is it a writ? Or you could do a writ
of what?
Of I want to say prohibition, or it might be the one with the word I can't say, but it's either one of them. The certiorari or the writ of
Certiorari
prohibition.
for error, so that's for another one. You want to do? You got mandamus.
Okay, yeah, writ of mandamus. I knew it was a writ.
Now, both of those, the first two we just said, happens to do in a higher court. How can you exhaust the remedy in that lower court?
So what were the two things that you said? You could do a writ of prohibition or a writ of mandamus, you
It
said?
just depends. I said a prohibition is for something else, but you can appeal. It was said first, and then
appeal.
You was basically saying a mandamus. So now, what remedy can you exhaust in that same court? Both of those two were in a higher court. So what can you do in that lower court to still make sure that you exhaust all remedies?
I don't really know the answer to that. I just know you have to you have to put your stuff on the record. Like you have to make sure everything you object and, put everything on the record. So because in the higher court, you can't present any new evidence. That's what I understand.
Right. So what would you do in that lower court? Anybody?
Motion reconsideration.
Motion to reconsider and citing the due process violations, because motion to reconsider is exhausting the last remedy that you have before you go up to the appeal. It also shows that you preserve the records for due process. So how does proof of service impact the validity of subpoenas? We already answered that. What does subpoena, why must subpoenas be specific? We already answered that. Let me see. Let me get one that we kind of haven't answered. Why is maintaining the chain of custody crucial for admitted evidence? It's the last one. Why is maintaining the chain of custody crucial for admitted evidence?
To prove that it wasn't
To prove due
altered
process.
or contaminated in any way, altered, debarred, whatever.
I would say it certifies its authenticity.
Prevents spoliation.
Who holds the rights?
Preserve the integrity of the evidence.
Correct. Absolutely. We want to preserve the integrity of the evidence, the authenticity of it. Why does motion, no, we're not going to do that. What authority do court officers enforce subpoenas? How can it? We already answered that one. Okay. What is the ultimate purpose of enforcing? No, what is the ultimate purpose while you're in court proceedings? You said what?
Preserve the record.
Say it again for the people in the back.
Preserve the record.
Preserve the record. Okay, another question. If you do not have a court reporter and you made objections during the proceeding, how can you preserve your record for the objections made? What should you do?
Go home and write an affidavit.
An affidavit, and also what?
Put it on the record in the case.
Put it on the record. That's what you need to do. That way, because you got to remember the appellate court is not there with you. So they can't see or hear anything that's going on. So to your best ability, that's why you can't act in emotions. You need to be fully ready to see everything, right? And that way you can have it all ready. Because when it makes it up to that higher court and they see these procedures are being violated in many different ways, especially one of the main things is the establishment of jurisdiction as well. And I always tell y'all this because that's one of the things that has to be proven. And a lot of people think I'm crazy when I say, like, man, go in the court and question everybody. I don't know who the freak you are. I don't know who you are. How do we even know? Like, remember, we are to literally protect our rights in the Constitution from domestic, right, and foreign terrorism, right? Both domestic. So that means that I don't know you. I gotta question everybody for validation, right? So let me ask you guys this. What happens if you in a court and you in a Zoom court and they cut off your mic, won't let you speak, turn you off? Or the judge say,
Violation of
oh,
due
what
process.
happens when the judge say, no, we're not doing that in my court today. You're not gonna, you can't say that. I'm not gonna allow you. What happens? What are they doing?
Violating due process.
For your what? Opportunity to be what?
Heard.
Heard. Y'all got to deal with these people. Now, here's another thing. To all y'all out there, stop going to make complaints about police officers in the freaking police department. It's stupid. That's like saying you a resident and subject to that form of jurisdiction like you're under them. Like, why am I finna come make a complaint here with you guys? Listen, we finna go and make a claim higher. And we going straight to the risk management of the city or whoever deals with those things as well. Yes, we're going to do that. But it's always best for you to be able to preserve the record for yourself. And remember, preserve the record does not start in court. Preserve the record starts the minute you are in with the officer. You should be preserving the record. Preserving the record is one, asserting your rights. Let it be known, speak loud and clear. You don't have to, all you got to do is speak, guys. And that's another thing. Speaking, saying that you do not consent to whatever, that's enough. That's all you got to do. You don't got to wrestle, jerk. You don't got to do all that. Just sit back and smile. Just smile at them. They don't even know what you're smiling for. What you smiling for? They gonna hate it you smiling in their face and you so calm. You know what I mean? Like, y'all got to really sit back and chill. And just watch and pay attention to due process. Everything that they supposed to do right. And I told you, due process is a lot. It's a lot to take in consideration that in the heat of the moment, these people are what?
Human, and they make human errors.
They human, they gonna make human errors, and they operating fully off ego. They ready to trip. Man, I want to try this new move we was doing in training camp. I hope he get wrong today. They'll start putting in them gloves and say, what? We got us one, boys. We got us one. I'm finna get to rough him up. And that's how they feel. They already operating on ego. That's why I tell y'all, like, just be patient. Sit back, chill. Watch them mess up. They're going to do it. They are going to do it. And then you want me to show you why people going to continue to make errors? Because the first thing people use as an excuse is what? What they say?
Fear for my life.
Ain't nobody perfect.
I didn't know.
So since everybody out here saying ain't nobody perfect, that means you leaving the leeway and excuses for you to mess up. So since you think that way, we can just follow your trail behind you on your job, and we're going to find errors every day. And you know that because you watch them turn on emergency lights. They'll turn on emergency lights just to run a red light. And no emergency around. You know what I'm saying? They steady parking in places they ain't supposed to park at. They do all kind of stuff, and they'll give you a ticket for the same thing. They don't be having them damn tag lights either. They don't. They be speeding, doing all kind of stuff, man. Chasing folks through the reckless endangerment, chasing folks down the highway through neighborhoods where kids can run around there doing 190 miles an hour chasing somebody. You can literally catch these folks doing something wrong every single day. And the same thing they'll chastise you for. That's why I be trying to tell y'all, like, and it's crazy because we sitting out here fighting for stuff, and it's like, do y'all really care? Y'all so, like, this is what get me. We always say, get out and vote. Go and vote. Voting don't do shit if we ain't holding nobody accountable. That's the most done. Like if we ain't gonna study, if we not gonna study the law ourselves, hold these people accountable for the oath that they took. We didn't take the damn oath; they took it. We the beneficiaries of their performance. So if that's the case, then as beneficiaries, we have to hold the trustees accountable, hold them fully accountable. If we're not doing that, we wasting our time. How? And you wonder how corruption happened is because the same people, the beneficiaries, is ignorant. They're dumb. We just let them do whatever. You know? We got to stop that. It's really, really, really crazy. And then it's to the point to where, okay, I literally seen you know, those two people I was telling y'all, what y'all say his name, Tadawa, some shit like that. I forgot what y'all said his name was. But just watching him and the other lady, was her name Stacy?
Jessica, I thought.
Jessica, some whatever. Anyway. But just to hear what they saying, and they go into cities. And it's funny because what they doing, they go into cities and saying, hey, you did. This is a criminal prosecution. And under this criminal prosecution, it was supposed to be up under a grand jury indictment. But you did it by information. So all these people that you got in jail by information and not by grand jury indictment is a violation of due process. And the reason why they're saying that is because, well, it's really true. Because the things that they're holding them in there for, like if it was theft of property, if they caught you with some illegal drugs or something like that, and then they want to take away your liberty and all of that and hold you, you know, then yes, they have to literally do indictments for that. They can't just literally do it by way of information because it's a criminal form of prosecution. Not only that, since it's that, remember, bench trials is a no-no. You got a right to a jury trial and the right to be presented all evidence. So we just gotta make sure that we know what's going on. They either have to move that venue out of that court and get you to a place where the trial can be held, or they definitely have to dismiss that case out of their court. There's no way around it. So it has to be there. And if anybody's not going under penalty and perjury, that's another thing. Especially when y'all be in these court cases with these banks and all of that, man. Listen, anybody that's saying anything, put their ass under penalty and perjury. I don't care who it is. But we letting these people get by with these statements and stuff, and ain't none of them under penalty and perjury. None of them. They're just out here saying anything, and it's considered to be facts. It can't be. Because now we have to recognize that it's what? Hearsay. Right? If it's hearsay, then that means we have the what? Motion to strike. Motion to suppress. You know what I'm saying? So it's just what you got the right to do and right to have, and just to make sure that you do get it and have it. And implement that, because it's very important. Very important. Continue to know the rules and procedures. Like I said, guys, on this journey, I've seen a lot of people quote law, no law, say this, say that, and that's great. But not too many people are operating and knowing how to get the remedies through these procedures of the court. So I'm glad we got to do this today, just so you guys can see where you kind of at right now. Some more things that you need to pick up on. So these ebooks are available to you as well. Go and get those. Don't forget about the raffle ticket, guys. Buy 2 raffle tickets, get an ebook free. Raffle tickets is $10 a piece. You get a chance to win a 2026 Toyota Camry coming up February the 21st, 2026 here in Huntsville, Alabama. We're having a pop-up shop. So you're more than welcome to do that. If you want to know more about it, just send me a message from whatever you're watching it from, or email us, as you already know how to do. Tonight's been great. I hope you guys have fun with these questions. Y'all have fun?
Yes.
Yes, I did.
Yes, overwhelming but fun.
Very good. Very
I try to implement these things just to see and keep it fresh, since we just got done covering these 2 classes, right? And You know, it's really about you guys and what you want to do and how you want to do. This is a spiritual thing first and foremost. Do know that. Don't take these situations personal. A lot of the stuff that I found out to be like, you might fall into a situation and it's not even for you. It's for somebody else to see the truth, to see, you operate and do what you do, and then awaken them. It could be the officer, it could be a judge, it could be a prosecutor, it could be your family member or whoever. Like, it's for them to see. So don't take everything so fully personal like that. You know what I'm saying? God might be using you as a vessel to be able to open up other doors, right? Yeah. So. Oh yeah, for sure, man. It happens that way, and I will say that. So, don't take this journey to heart in a way to where you get so emotional about it. Yes, you're gonna go through every emotion about this because that's kind of how it is. Remember being a kid trying to learn something and trying to become the best at what you know how to do or whatever. You go through every emotions doing that. This is the same thing. So yes, you're going to be frustrated because you're not learning something at a faster capacity than others or whatever. It doesn't matter, guys. Time plus consistency equals growth, and that formula will work no matter what. Guarantee it. It also means that if you're going to spend time being ignorant and being consistent in that, then you're going to keep growing in ignorance as well. So make sure that you stay knowledgeable, challenge any and everything. Even what I'll say, verify. Go back and verify again. Then verify it again to make sure, and then apply. Make sure y'all do that. And nobody knows it all. Nobody knows it all, guys. I'm still studying. So if you think what I know right now, that's the all in all, it's not. I'm still studying. I got some stuff that I want to show y'all that I got to make sure I got it all the way packed down first. But yeah, it's a lot. Real talk. So. And you're going to see people come out with other procedures or processes that they do, and it works, and it's great. And you're like, wow, that's dope. I want to learn. I want to know. And don't be afraid to learn. Remove yourself. Sometimes the messenger might be a little rough for you, but oh, well, you're not there for that, to worship or praise that individual. It's just to receive the knowledge and information that God has set for you. That's why I say, when you at that present moment, all throughout the day, the universe is speaking to you about different things that you are requiring, warnings, signs, whatever throughout your life. Are you paying attention? And if so, take heed, right? Take heed and reflect, pray, meditate, then move. That's what you do. Appreciate y'all tonight. Y'all have a great and beautiful night. I will see you guys Monday for work sessions, but I'm pretty sure I'll see you guys tomorrow sometime when I get on here. Have a great one.
Peace and blessings.
Thank you. Peace and blessings.
Thank you.
Peace.